Hey there. This is a brief orientation on the concepts of zoning and liability and as it applies to agritourism. My name is Andrew Branan. I'm an extension assistant professor at North Carolina State University, Department of Agriculture and Resource Economics. And these two issues are when folks ask about, you know, what certification do I need to be a agritourism operation? What licensing? All of that. There really is no, license that you need um, to operate a farm. But the most relevant, immediate applicable regulation that a farm faces is going to be the activities that occur on that farm in relation to whether the county has whether the uses in the zone for that area under the county zoning scheme are compatible. And I'll explore that. As a bit of a preface, disclaimer, this presentation is not legal advice. It's for education purposes only. What I'm doing here is just merely raising some issues, the answers to which I'm offering my opinion, which really all law is until a judge or jury rules on a particular fact situation. But at the end of the day, there's there's input from various regulators in the county, normally the planning office and the permits department for construction. That's going to be where you go to find out, what their position is on constructing various buildings used in agritourism. So before making a building decision, speak to your county planning office. Again, they have the official say and enforcement power. They may not always know the answer. The question provides you a opportunity to educate them and help them form their opinion in your favor if they don't already have a set policy on buildings on bona fide farms. But the one maxim to take away from this in the law, and again, particularly in zoning and building buildings, construction of buildings, the maxim that you hear are better to ask forgiveness than seek permission. It's not a thing. It's not something that that county administrators are able to, in my opinion, offer. It's a misapplication of law. It exposes the county to favoritism and enforcement of law, and that undermines their authority in terms of applying the law equally to everybody. And the other disclaimer too, always speak with your insurance agent before increasing the number of potential customers coming to your farm, doing something new that's going to target a new audience, draw more people, because that's increasing the insurance company's risk. And that's something that under your current contract, they likely haven't bargained for. So, as a orientation to these concepts of zoning and agritourism liability, let's differentiate between between liability and regulation. Liability first is a theory of law that has developed over hundreds of years in the English common law system, whereby if you do an act and another person is injured, a question arises about your responsibility for that act, your liability for that act. And if the person that is injured can prove certain elements, then under the law, you are obligated to make recompense for the injury you have caused. What we call making the plaintiff whole, where they've lost wages, where they've been injured, pain and suffering, various economic measurements that the plaintiff has to prove. If the right elements are there, which I'll talk about in a little bit, then you become the person who injured the other party becomes liable to compensate them. The concept of regulation, on the other hand, is not. I often hear, am I liable if I violate this regulation? It's like, well, that's actually a legitimate question, but normally the term liability is not attached to regulation. Regulation is merely the government's inherent police power to protect the public's health and welfare. And as such, liability tort law throughout the centuries has informed the public, has informed us, has informed public policy that perhaps we should put certain regulations in place to prevent the types of injuries that might commonly occur. The most obvious one in farming I can think of is food safety, whereby processors of meat, poultry are required to, they're heavily regulated under an inspection regime because doing so prevents the outbreak of foodborne pathogens. Well, once upon a time, there weren't those regulations, and people had to resort to the common law of common personal injury and tort law to try to get compensation for those types of things. While regulations don't offer compensation to injured people, they prevent injuries from happening. So your option as an operator is to forego or comply with the regulation as it's written, as it's interpreted by the closest governing body to you, or just forego investment in the operation. If saying that, well, this regulation is too expensive, I'm going to ignore it, puts you at risk. The primary risk is that if once discovered, your discovery is a lot easier these days in the realm of social media and just in general. The government does have the regulating power, does have the ability to shut you down under penalty of law, of criminal penalty, if you do not comply with that. So you comply or don't move forward. But if you disagree with the application of the regulation to you, you are certainly under our guaranteed right of due process under the North Carolina 5th and 14th Amendments. You are allowed to, you can litigate. You can litigate the application of the regulation, both at the agency that's applying the regulation or then in court. And so, and that, again, that's your right when you've been, essentially your liberty to do whatever you want has been infringed upon by the government. You have a right to challenge that. So the relationship between liability and regulation. So the elements that I spoke of about liability, when someone injures another, the person that's injured, if they're bringing a court claim against the party that's injured them, they become a plaintiff, and they have 4 key elements that they have to prove. First and foremost, they have to prove that the person that injured them owed them a duty not to injure them, essentially, to take steps to make them safe, depending on the circumstances. That the defendant breached that duty. They fell short of what they were reasonably required to do to prevent that injury. That failure, that breach of duty, is the actual proximate cause, meaning it's the thing that caused your injury. It's not proximate cause is not where maybe they breached some sort of general duty, but you were injured by some other more distant cause than their actual breach. And then fourth, the plaintiffs have to prove damages. They have to prove that the dollar amount of the injury, once they prove the first 3 elements, then it becomes a matter of quantifying what the damage is, and that becomes what the measure of the defendant's liability. Well, the relationship with regulations is that, as I mentioned, normally regulations have been developed over time to prevent these type of injuries, to prevent the public when participating in the commercial arena and as customers, as consumers, to take the burden off them, so to speak, in terms of risking their safety. And as such, if they're risking their safety and they're injured, then their only recourse is to go to court and prove these 4 elements. So regulations have developed over time to try to keep the public safe, to regulate the activity of economic actors in their interaction with consumers. Well, if as a business, a regulation is ignored or violated, that can change the dynamic of the liability proof requirement on the part of the plaintiff. These four elements under liability, the plaintiff has to bring the case. The plaintiff has to prove these elements. The defendant doesn't have to say anything, although it's usually in the defendant's best interest to introduce facts that will cast doubt on the plaintiff's, the truth of the plaintiff's facts. But if you're shown as a defendant to have violated a regulation, and that regulation was the type to prevent that type of injury to that class of person, a customer, a child, somebody that happens to be using a certain type of product. If that can be shown, then the law presumes that the plaintiff is liable. The defendant is liable. The law makes that presumption. This is known as negligence per se. And at that point, the defendant now has the burden to prove that they weren't the cause of the injury, and which can be more of a challenge. So I'm going to bring up this concept in a purely hypothetical situation related to COVID-19. A question right now among agritourism operators is, can they safely operate in this environment that we're in right now? And as businesses, there are now regulations about how businesses operate in the realm of COVID-19, coronavirus, whatever we're going to call it, and the businesses have to comply with that. Its enforcement has been somewhat spotty. There's been more citizen shaming and all that, but this takes it to a little bit different level when you're operating a business and you're having people come to your business and come into contact with you, your employees, and with one another. So let's look at the executive orders briefly. Let's consider these to be regulations. Governor Cooper's executive order number 147. What Governor Cooper and his people are doing here are requiring that certain types of businesses where employees are in close proximity to one another have to do social distancing and wear face coverings, and they're required to do that as by operating. You're regulated to have to do that. Your employees have to do that in order for you to operate. Well, here we have, and again, I think probably the idea behind this is that we have farm labor group, crews, migrant and H2A that are working in close proximity. They're living in close proximity, and perhaps in housing supplied by the farm operator. And so that maybe we're thinking of it in that light. But notice here that the executive order refers to NAICS 1152, which is agriculture. So if you're employing people in agriculture, you have to have social distancing and wearing face masks. Well, so an immediate question arises, and this is really more of a logic exercise, is, well, does that include agritourism farms? And these aren't migrant operations where you have a lot of workers picking vegetables, or you have H2A workers picking vegetables or doing other tasks on the farm. And so the answer is that we don't know if an agritourism operation, which so often needs to be classified as a farm, as you'll see for zoning purposes, whether an agritourism operation is agriculture under NAICS 1152. Well, just in a situation where something's happened, either side's going to be bringing forward their evidence for persuasion. And this is one that I would bring forward to say that, yes, agritourism is recognized as agriculture, and the employees of that operation were required to have face masks and do social distancing. And I do that here just by pointing out that on the ag census, if I can enlarge this just a tad, the ag census, agritourism revenue is specifically requested in terms of, how much income did you get from farm-related sources. So to me, that's evidence that agritourism is considered to be agriculture. Does that tie it directly to NAICS 1152? No. Could that leap of logic be made? perhaps. And as later in this discussion, you'll see where farm agritourism revenue becomes very, very important to the classification of that farm for zoning purposes. So, so let's move forward a little bit in this COVID-19 scenario. So here are our basic phase 2 restrictions, and each agritourism operator has to really make their own decision on, can they safely operate, but also do they fall within these definitions. And I put a couple here that likely apply to an agritourism operation. Of course, you might have an indoor farm stand that you've got to keep at 50% capacity. If you have a wedding venue, you have restrictions there. Day camps, maybe. Those are open with no restrictions, at least under phase 2. Playgrounds are closed. So if you have, play equipment on the farm as part of your agritourism operation, it's likely that stays off limits. I put a link here in the presentation just to illustrate what was done in Washington State. I'm not certain, I couldn't find that we've done this here. And I did not analyze their particular phase 2 and phase 3 requirements, but they have agritourism guidance. And it's probably worth taking a look at, just in general, seeing how agritourism operators up in Washington State are complying with whatever their phase 2 requirements. They're likely not that different than ours, assuming that they're using the same science and consensus. So let's move this compliance with COVID-19 regulation into the theory of someone getting sick. Now, this, again, this sounds very far-fetched, but anyone can get sued. And so I've posed a question here, and really let's call it more of a hypothetical, but it's meant to illustrate any type of injury that could happen on a farm, and what the injured person is doing in terms of whether or not you've complied with any particular regulation that applies to your farm. Again, this one for agritourism, I'm just limiting it to COVID-19 because there aren't others that are necessarily relevant in terms of zoning and whatnot. Those don't really tie that closely to injury on farm. So here's the question. So somebody gets hurt or sick from, they catch COVID-19, and they say, I went to that farm and they owed me a duty to enforce face masks and social distancing under the governor's orders. They did not enforce those rules, and as a proximate cause of that failure, I contracted COVID-19 and suffered damages. Now, it'd probably be very, very difficult for it'd probably be very difficult for the plaintiff to prove that they contracted COVID-19 at your farm, because contract tracing is not an exact science. Contact tracing is not an exact science. They've been in contact with lots of different people. We don't know where it's been caught. But let's throw a what if out there. What if that public health officials have identified multiple cases that were traced back to an agritourism farm? They identify it as a super spreader site, not an official term, but you know what I mean. And it's documented somehow that through social media, people took pictures, that the farm didn't follow the governor's executive order. Employees weren't wearing face masks, or they were wearing below their nose, or they weren't social distancing, or the playground was open, or think of all the things that might be a violation. And that's where you have somewhat of a failure there on the part of the farm to take reasonable steps to keep its customers safe. And taking that a step further, what if that became the theory of negligence per se? The court, it's not outside of the realm of possibility that a court could say, Okay, you're right. Multiple cases have been traced back to this farm, and we have evidence that this farm was following no safety guidelines. We're going to apply negligence per se, and it now becomes incumbent upon the farm to prove that that customer did not catch COVID-19 at that farm. Again, it sounds, I'm laughing because it sounds somewhat ridiculous even throwing this scenario out there, but logically logically under the law in terms of how liability is applied, particularly in the realm of regulation compliance failure. This is a sort of a logic model on that. So anyways, that's a little primer on relationship between liability and regulation, just using COVID-19 as a hypothetical backdrop.